can I show you an issue with limitation period? Just a point of comparison. Let's look at limitation periods. When I say, if we do it by comparison, the Act specifically references the Limitation Act and also references the Home Building Act. By that I mean, let's look at this as an illustration. On this slide, we had the limitation periods up top. On the left-hand side, we have the comparison with the different pieces of legislation, which we'll briefly discuss. And on the lower horizontal bar, we have the number of years for which you might make a claim for building defects and or design defects. Starting with the Limitation Act, 1969, there is a 6-year limitation period for making a claim for contract and tort from the date of completion of the work. The Home Building Act gives you 2 windows of opportunity to make a claim. For 2 years post completion of the work for minor defects, 6 years from the construction or completion of the work for major defects. So we're dealing with major elements of a building used that are essential for its stability and which are vital for public protection and essential to human life. So 6 years. By way of a comparison, the Environmental Planning and Assessment Act there provides what we call the long stop provision of a 10-year limitation period, which finishes or starts from the date on which the building work is completed. That is probably the end point for making a claim for building work and building defects. By way of comparison, the Design and Building Practitioners Act, I've flagged a couple of different scenarios that will apply. The first is this, that the Act is retrospective. So the duty of care will operate from the date of assent to the legislation, which was the 11th of June, and it will mean that there can be claims for compensation which go back 10 years prior to the legislation commencing. So it may allow an opportunity to claim building defects and design issues under this legislation. I would suggest that, for example, that would need to be actively considered. The Act specifically refers to there being a provision for proceedings which may already be commenced in relation to building and design defects. What I think the Design and Building Practitioners Act seeks to do is expand the role or expand the consumer benefits open to parties, that's landowners that have suffered a loss as a result of defective work of a design and or construction nature. One thing that I also point out, and we might go back to the preceding slide with this, some of the effects of this Design and Building Practitioners Act are this. You have an increased number of potential defendants that may be caught up as or as parties to potential legislation. This is because the definition of construction work is significantly expanded to capture not only construction work or building work as traditionally known, but also to capture design work. That's the first thing, liability. We have a second issue with multiple defendants and wrongdoers, as seen as an example in the La Crosse decision, which implicated not only the builder, but also the designer, the fire services engineer, and the certifier. So I'd say to you that using La Crosse as an example, this legislation that we're just considering actively considers there being multiple defendants and wrongdoers that may be regarded as concurrent wrongdoers in a similar way that La Crosse found. And so that means that any person, any lawyer considering commencing proceedings for design and or building defects would need to consider that there would or there may be more than one course of action to seek to provide recompense to a person, a landowner, that has suffered a loss. The third issue deals with the differing limitation periods, which we've discussed a little bit earlier, but it's relevant this way. Under the Home Building Act, you have a 2 and a 6 year period for minor defects and 6 years for what we call major defects. Before this legislation came into being, with the effect of the decision from Brookfield Multiplex and the High Court, 2014, that said that there was no common law duty of care owed by a builder, constructor, to a subsequent owner. This legislation, the Design and Building Practitioners Act, really expands the role of a duty of care. It says that not only a building practitioner, but design practitioners will also face potential liability in relation to defective design and or building defects. The legislation specifically makes provision for the retrospectivity of it. So in other words, it may permit a claim to be made 10 years within commencement of the building work. Now, that is a significant potential liability opening up for design and building practitioners going back that far. That's specifically referenced in Schedule 1, Part 5, Clause 5, or it may be 10 years post the, within 10 years after the loss became apparent. But let me make this point. A loss becoming apparent of the type of defect which is the subject of this legislation might not actually become apparent until several years after the building work has finished. Several years after the owners or residents have assumed occupation of the premises, which potentially means that a 6-year limitation period, which you might expect as being the outside claim period for commencing proceedings for a major defect, as we'll call it, could actually expand to much longer than that, possibly 8 to 9 years post-construction or completion. Something to bear in mind when you look at the piece of this legislation. And I think that was part of the thinking behind the legislation. In other words, to provide a greater width of compensation or availability for claims. Part of the issues that we've already highlighted with the legislation also deal with a differing standard of care. So depending on the assessment by the relevant expert about the nature and extent of the defect and what that is, with the building practitioner having to take all reasonable steps, as opposed to a design practitioner having a mandatory obligation to ensure that the design declaration and compliance meets the relevant Australian standards in all BCA. That is the reason for this slide, where I suggested that a little bit of the unknown about the duty of care and the width of that needs to be considered when we're looking at the Building and Design and Building Practitioners Act. Some of these issues we've dealt with, but let's have a look at the last few points on the applicability of this legislation. Proportionate liability, yes, that's an important one to consider. If you're acting for a builder and or a developer, consider that particular issue. If you are, based on the Lacrosse decision, where the builder had expectations based on its contracts and subcontracts with the designers, the certifier and the fire safety services engineer, each of those was found to have failed to have honoured their obligations in a contract setting to the builder. On that basis in Lacrosse, the court found that they were considered to be a concurrent wrongdoer with the builder. Part of the reason behind the appeal from those parties that were found to be responsible as defendants lies in the finding that despite the finding of the VCAT decision in Lacrosse, which pointed the finger to the builder, but then failed, and also found that he did not fail to exercise reasonable care, but also the finding that these other parties, the engineer, the fire safety services and the certifier and the architect had all breached their contractual obligations, I'd suggest to you that increasingly we'll see building defect issues and design issues involving multiple defendants. Requires good record keeping from a developers and contractors setting, understanding what was requested to be designed, what correspondence flowed during the course of construction relating to responsibilities for design, particularly if you are responsible as a builder for a design construct. Means that you have assumed a greater responsibility. Also, I'd suggest to you that the understanding of whether particular liability lies will be important, and this will be determined by appropriate expert evidence. It's important to understand at the outset when we're advising either an owner and or a developer, a constructor and or designer, firstly, what is the extent of the problem? Where are the defects? How long they have been there? What are the nature and location of the defects? To understand whether these are something which are a maintenance issue. On the other hand, they may be of a lesser nature in relation to, so they might be found to be out of time. If they're not of a major structural issue, falling within the definition of the Home Building Act, and regarded as a serious construction defect, the 2-year limitation period may be expired. On the other hand, if they're found to be more of a major issue, then they may permit a claim to be made for the major design claim for responsibility, which would bring them within the 6-year period. The importance of suitably qualified experts at every turn is important to determine liability, both from parties acting for owners and also designers, builders and developers. Lastly, the issue about insurance. The Act mandates registration and insurance by both design and building practitioners. But at the present time, following La Crosse and in view of the findings with the multiple issues arising in relation to aluminium composite panelling, the insurance market has been thrown into flux. In other words, there have been a number of claims where involving aluminium composite cladding where various parties have not been able to claim on their professional indemnity insurance. That issue is still not resolved, and I suggest that the effective passage of this legislation as a tool to try to aid enforcement and recovery for owners and people suffering loss has to go hand in hand with adequate pricing and insurance to understand precisely what the risk is that the insurers are to take on, whether the cover that they are providing is adequate, and then to understand the pricing of that before they go to the market. Just on that particular issue, in terms of pricing of insurance, I thought I'd just briefly highlight some of the significant risk factors that happened and the risk reward. So by risk reward, I mean this. When we're looking at any person entering into a building or construction project, everybody does it to make money. We don't do it for the good of our health. But as the La Crosse decision found, sometimes the parties that are paid or receive less in terms of a recompense for their various efforts from a professional perspective may also find that they have an inverse risk, what we call a misreward in terms of the damages that they may face. If it's ultimately found, as they found in La Crosse, that they had failed to reasonably comply with their contractual obligations. For example, the builder, Ilyu Simon, had a fee of 96 million to build the building. It ultimately was found to bear zero responsibility in terms of responsibility for the damages. The architect, fees of 2.66 million, ultimately found to be 25% responsible. The superintendent, was found to be responsible. Well, they had significant fees, but they had a zero apportionment. The last two parties, however, the building surveyor and the fire engineer, both had relatively minor fees compared to the significant fees generated by the builder and the architect, respectively. So, for example, the building surveyor had fees of approximately $100,000. They were ultimately found to be responsible for 33% of the damages payable. The fire engineer, even worse, in terms of the risk reward, 39% apportionment of the ultimate damages of $5.7 million, but their fees were $33,000. The point behind this is this: there needs to be a real consideration for understanding whether the fees that we generate if we tender for a job are going to match the potential risk that we face if we get it wrong. As Lacrosse found, the surveyor and the engineer, for example, had failed to carry out due diligence in terms of the work that they were doing. The fire engineer could have, by reasonable inquiry, it was found by Judge Woodward, discovered that the aluminium composite panelling, which was ultimately chosen and installed, did not comply with the then known Building Code of Australia. The building surveyor was also found to be similarly liable and was found to had failed to exercise reasonable care in the performance of its duties. One has to say that for a relatively small recompense, their ultimate liability was considerably greater in terms of the ultimate damages. That judgment may not stay as it is, but I'd have to say to you that Lacrosse serves as a warning not only for design building practitioners, but also for the insurance market to understand the risk that one takes. How can one then have to read or consider the pricing of that in terms of issuing policies to these sort of building practitioners, what we call design practitioners, that one would think, based on their small fee reward, might ultimately be responsible in a large setting for significant damages.